Hi, I'm Stuart Goff. I'm a principal in the commercial and employment divisions of the firm, and today I'm going to be talking to you about the importance of employment agreements. Although an employer in New South Wales may be subject to various laws and industrial instruments, including the Fair Work Act and modern awards, there is still a necessity, and an important one at that, for having a written employment agreement in place with each employee. The main reasons for having an employment agreement in place include, firstly, it fills the gaps between common law, legislation and industrial instruments, as not every aspect of the employment relationship is dealt with by those items. An example is restrictive covenants. Secondly, it creates contractual obligations that provide an employer with another option when it comes to the employer's rights and remedies, again, such as clauses relating to restrictive covenants, as well as those relating to confidential information, intellectual property, self-serving injunctive relief provisions and indemnity clauses. Thirdly, often a modern award will require that certain items be recorded in writing, such as an employee's classification or an annualised salary. Usually the most appropriate place to ensure compliance with those requirements is in an employment agreement. Fourthly, when it comes to notice or payment in lieu, whilst industrial instruments and legislation may specify minimum periods, in the absence of a contractual clause, the employee may be able to claim for reasonable notice. Fifthly, employers also need to give consideration to the potential for an employee to work at different premises, such as where an employer moves to a new location. This is important because in the absence of such a clause in the employment agreement, an employee may be able to claim that the change of location is a fundamental change which, if they do not accept it, may lead to a claim for redundancy and associated entitlements. Those are just some of the reasons for having an employment agreement, appreciating that many other terms can be incorporated into such a document and also into separate policies and procedures. Albeit at the same time, an employer needs to keep in mind that they generally cannot contract out of or provide for less favourable benefits than those set out in an applicable industrial instrument or relevant legislation.